New York's gun laws continue to come under fire. A Western New York lawyer today made his case before a federal appeals court to overturn the state's requirement that handgun owners obtain a pistol permit.
But there is a lot more at stake than just that, as we hear from Channel 2's Dave McKinley.
They may change the standard for evaluating gun laws.
The case of Libertarian Party of Erie County v. Cuomo seeks to upend New York's more than century-old pistol permit requirement. Currently, once a permit applicant passes a police background check, it is then left to the sole discretion of a judge to decide if they get their permit, if they find they are of good moral character, and if, in their view, and only their view, has a good reason to own a pistol. Buffalo-based attorney Jim Ostrowski argues the determination is thus not only open-ended but overly subjective, and because it may be inconsistent from county to county, it's also arbitrary.
In New York, a pistol permit is considered to be a privilege granted by the state. In the Supreme Court, the right to bear arms is a fundamental right, so there's a huge conflict, and we're asking the courts to resolve that conflict in favor of the right to bear arms.
But the real aim of the suit is to target other gun control measures such as the SAFE Act. If they win, it could be expunged, as well as head off even more onerous proposals such as those for permit seekers to open up their social media accounts for decision makers to troll through before permits are granted.
That's all totalitarian nonsense, and we oppose all of that.
All of which, he argues, would keep guns from law-abiding people while doing nothing to prevent criminals who wouldn't abide by the restrictions in the first place from having them.
And we want to roll back New York's laws to what other states have, which is a lot fewer laws, and not in many cases lower crime rates.
That said, he does not believe everybody should be allowed to own a gun.
That if you're a felon, you can't get a gun, or if you're adjudicated mentally ill, or anything else would have to be of that nature of severity.
That it has reached the Second Circuit Court of Appeals means the case is now just one step away from the U.S. Supreme Court, which would have to grant leave for it to be heard there. That, by the way, is a $10 legal phrase for getting 5 of the 9 justices to agree to hear it. But given the current makeup of the High Court, Ostrowski is somewhat optimistic that that could happen and that they could win. Dave McKinley, Channel 2 News.